Ready? Start. The aforesaid resolution, taken by the full court on its administrative side, clearly indicates that the matter regarding his confirmation or otherwise or extension of his probation period for another 1 year was considered by the full court, but since his service was not found to be satisfactory on consideration by the records, therefore the full court decided not to confirm him in service and to dispense with his service and accordingly recommended for dispensation of his service on the basis of the aforesaid recommendation of the High Court. An order was passed by the government of Jammu and Kashmir dispensing with the service of the petitioner Parachin. These facts clearly prove and establish that the order of termination of service of the petitioner was not issued by the Jammu and Kashmir High Court, but it only recommended that termination as his service was not found to be satisfactory. The aforesaid recommendation was accepted by the government, which finally ordered the termination of his service. The aforesaid order was an order of the competent authority and issued by the government of Jammu and Kashmir. Since the said order was issued by the competent authority, it was a valid order and should be treated as such, although it was specifically not issued in the name of the governor. Parachange. In the present case, two orders are challenged. One, which was the order of the High Court based on the basis of the resolution of the full court, and the other one issued by the government of Jammu and Kashmir on the ground that they were stigmatic orders. Parachange. In our consideration opinion, none of the aforesaid two orders could be said to be stigmatic order as no stigma is attached. Of course, aforesaid letters were issued in view of the resolution of the full court meeting were the court of the High Court held that the service of the petitioner is unsatisfactory whether or not the probation period could be or should be extended or his service should be confirmed is required to be considered by the full court of the High Court, and while doing so necessarily the service record of the petitioner are required to be considered, and if from the service record it is disclosed that the service of the petitioner is not satisfactory, it is open for the respondents to record such satisfaction regarding his unsatisfactory service, and even mentioning the same in the order would not amount to casting any aspersion on the petitioner, nor it could be said that starting in the order that his service is unsatisfactory amounts to be stigmatic order. Parachange. This position is no longer restricted, and it is well settled that even if an order of termination refers to unsatisfactory service of the person concerned, the same cannot be said to be stigmatic. In Pavandra Narayan Verma versus Sanjay Gandhi, PGI of Medical Science, reported in 2001, SCC 520, this court has explained at length the tests that would apply to determine if an order terminating the service of a probationer is stigmatic. On the facts of that case, it was held that the opinion expressed in the termination order that the probation work and conduct has not been found satisfactory was not ex facie stigmatic, and in such circumstances the question of having to comply with the principle of natural justice do not arise in this case had the occasion to determine as to whether the impugned order therein was a letter of termination of service simpliciter of stigmatic termination after considering variation. Earlier decision of this court is para 21 of the aforesaid decision. It was stated by the court. Stop.